Amber Heard has once again been blown out of the water in her latest legal shenanigans, her latest attempt to sue, or rather counter-sue, in the New York Marine case. So today we're going to talk about how she's taking this giant L, this massive L in this new case, this latest of legal shenanigans for Amber Heard, and how this shows she continues to be just the delusional lady we came to know and hate during her trial against Johnny Depp. As always, I'm Andrew Esquire. This is the legal mindset we teach you to be your own judge. And today we're going to go through this latest motion of Amber Heard, which was really filed on March 9th, 2023. This is an in-chambers ruling on the New York Marine and a General Insurance Company versus Amber Heard case. This is a California case. It's in the California U.S. District Court for the Central District of California. It is at the federal level, so this is not a state level case, the federal level. And you can see this thing was just filed on the 9th, and it is a ruling, a tentative ruling in this case. So we can actually stand by what's going down here and the fact that, hey, look, we see her taking an L. We can probably stick by that. So I'm going to run through this bit by bit, explain what's going on here, what are the facts, and give you the basics on why she's taking this L. So this case, it is a motion, is ruling on a motion to dismiss Ms. Heard's counterclaim pursuant to Rule 12b-6, that is the rule regarding motions to dismiss, or alternatively require her to make a more definite statement and to strike certain allegations. Now, ultimately, they're going to end up winning on number one here. They're not going to need to get to number two or even number three. They're going to win on number one, but I'm going to explain to you why and a little bit of the facts here today. So New York Marine and General Insurance Company, maybe you don't know about them, but they were one of the two insurance companies that were covering Ms. Heard. The first was Travelers Insurance Company. The second was New York Marine. So she had two separate policies that were applicable to her. Now, they're suing her. They're in fact filing a declaratory relief action against Amber Heard. They filed that on July 8th, 2022, shortly after she took that giant L against Johnny Depp. Now, she, this year, had brand new, not just responses for them, but claims, but actual court claims, which she has now been beaten back on. And what were those two claims? Those were counterclaims filed in January of this year, and they were for breach of contract and tortious breach of implied covenant of good faith and fair dealing. So these are two contract-type breaches by New York Marine and General Insurance Company. Now, what we're looking for here, what we're really concerned about when we talk about this in this case, is did they break their contract as the insurer? They were supposed to insure Amber Heard, so did they do that? Did they fulfill their role as the insurer? And Ms. Heard is claiming, no, they did not, and we'll see why here. So I love how in this lawsuit they give the actual facts of the case. And one thing we do not see in the mainstream media out there is them putting out this basic fact about the case. They always misrepresent it. They always go back to, you know, we got to listen to Amber. We got to pay attention to her, even though she lost. But straight up in the case, they tell us here in June 2022, the jury in that lawsuit, in the Depp versus lawsuit, returned a verdict against Heard on 3 counts of defamation. They proved that Ms. Heard defamed Johnny Depp. That's something that the media still refuses to say outright. They'll couch it, they'll caveat it, but the facts are the facts, and they got to deal with them, and Ms. Heard's got to deal with them. And of course, she tried to appeal, but that was handled regarding a pursuant to a confidential agreement. So that's an agreement we'll probably never see between Amber Heard and Johnny Depp. Probably involves her shutting up and going away regarding any allegations against him or future allegations against him. However, she gets to sue her insurers. Why? Well, she alleges that they messed with her, that they didn't do a good job. Specifically, she says that despite timely notifying New York Marine of Depp's lawsuit and asking New York Marine to defend her, and despite New York Marine's promise to do so, New York Marine actually did not provide a full and capable defense. So we'll get to that in a second. To which she asserts she was entitled and failed to pay attorney's fees and costs she believes that New York Marine was obligated to pay for her defense, and acted in other ways that she contends prejudiced her and her defense. So she's saying that the defense she received wasn't full and capable. Now, mind you, she was also being funded by Travelers. Travelers was also bankrolling her at this trial. And mind you, that she selected the counsel. We're going to see this fact over and over again, but she selected the counsel. New York Marine said, okay, that's fine. We're just going to pay for it. But she's saying that New York Marine should have gone out of their way to give her additional counsel, to give her an independent counsel, a third counsel, because they had delivered her a letter, specifically a reservation of rights. They had said, hey, we reserve our right to pull coverage if we find out that you intentionally violated our policy, right? You intentionally did something that violates our policy. Typically, if you do something like fraud, or you commit, let's say, a felony, you're in some way making material misrepresentations, that can void your insurance policy. Your insurance does not have to cover you no matter what. If you lie to your insurance company, yeah, they can void your policy. So they sent her a letter saying, hey, we may void your policy. We reserve our right to do that if we find out that you are a liar and you defrauded us when you signed this contract, when you signed this policy. And they're very smart to do so. They're very smart not to trust Ms. Heard. I think all of us agree that Ms. Heard is not a trustworthy person. And of course, she didn't like that. That's something that now she is trying to say, okay, because you sent me this letter that you might potentially, once again, they didn't do it and they haven't done it. They didn't pull her defense, and say, okay, we're not during the trial, we're not covering you, whatever. No, the trial's over. The appeal's done. She's at an agreement. And at no point did they pull the representation during that process. However, they did agree to reimburse the Travelers Commercial Insurance Company, i.e. Travelers, which is her other insurance company. And now, of course, New York Marine is saying, hey, look, this is BS. We got to get rid of this Heard's complaint because we did everything we had the duty to do. These two counterclaims, we got to get rid of them because we had, no duty beyond what we did. We had no duty other than promising to pay. That's all we have to do. That's all we're going to do. That's all we should be required to do. But Amber says, no, we needed a separate counsel. I needed an independent counsel, something called a Cumis counsel based on the Cumis decision in California. Now, I don't want to go insurance geek and go all into, the insurance and insured. Frankly, it's not that important. It's going to bore you to death. But that decision in California said, look, if you've got a conflict, you kind of got three separate issues. If you have a conflict, once again, if you have a conflict, you can either say, F you, we're not covering you, and then face, a potential breach of contract claim, and you're going to have to litigate that between the insured and the insurer. So you're definitely going to go to court on that one, because if you say, hey, I'm not covering you, they're going to sue you for breach. So you've got that option. You can kind of eat the costs and just say, okay, we're going to cover you and we're going to eat the costs. Or number three is you can reserve your rights and say, okay, we reserve our right to pull. And if you do that and you find a conflict, you've got to have an independent counsel. You've got to issue an independent counsel. So you've got somebody to represent you, and we have our independent counsel over here to represent us. So there's no conflict between the corporation, between the insurance company, and the insured. So the real question is, Elaine Bredehoff and the team that was behind Heard, were they ever representing the insurance company? Because that's an allegation out there. I think the mainstream media tried to block for Amber Heard and say that and say they're covering for the insurance company, not for Amber. Who did they owe a duty to? So we're going to find out that here. The first thing is, by the way, we got to remember that when the court was reading this, and this is why this is such an L for Amber, the court, under a motion to dismiss, has to construe everything in the light most favorable to Amber. Right here, it says under Rule 12b-6, this is the motion to dismiss standard. You have to construe a complaint in the light most favorable to the plaintiff. In this case, because it's a counterclaim, the plaintiff is Amber. And accept all well-pleaded factual allegations as true, as well as all reasonable inferences to be drawn from them. Imagine that. You're having to accept all of Amber's facts as true and put it in the light most favorable to her. And you're saying she still lost? Let's find out why. So if we go down to page 8 here in this hearing, this tentative ruling, we find out why. And that's because even under California law, which is very weird, once again, don't recommend California for anybody setting up a business or living or really doing anything. But under California law and the California Insurance Code, you only are required to provide an independent counsel when a conflict arises, when the insurance company actually says, you know what, we got a conflict here. Now you get independent counsel. The right to independent counsel is recognized. Was founded on the predicate of the existence of a conflict of interest. So merely sending that letter, the letter alone was not enough. But the whole point here is that New York Marine's interests did not conflict with Hurd's, and a conflict had not arisen because the Virginia Council had no obligation to New York Marine while they were representing Hurd. See, they had no duty to New York Marine. They weren't working for Marine, they were working for Hurd. Elaine Bredehoff, as shitty as she was, and mind you, she was a horrible lawyer. I still stand by. She did one of the worst jobs I've seen on trial. However, Elaine was representing Amber. She was not representing New York Marine. And you can see that down here. The court just gets straight to it and says the court believes that the appropriate boots on the ground question in first attempting to unravel that issue, to whom did Hurd's appointed Virginia counsel owe their duties? Who did Elaine owe her duties to? The answer, under Virginia law that governed the performance and expectation of those attorneys, was clearly only Hurd. The facts are unambiguous. The attorneys did not represent anybody but Amber. Where there is no possibility of conflicted loyalty, as is always be the case in Virginia, the answer is the same under either Virginia or California law. There's no right of appointment of independent counsel. And because of that, this court, when you go down here to the conclusion, will dismiss Hurd's breach of contract counterclaim, likely without leave to amend. They're dismissing it with prejudice. Likely, there's a tentative ruling. They might change that. They might be able to make some argument there. They should allow them to update that. But it is blown out of the water. And that's one claim. Remember, breach of contract was one. The covenant claim, breach of the implied covenants, that's also blown out. See, we'll dismiss Hurd's implied covenant counterclaim with leave to amend. The court need not resolve the alternative request for a more definitive statement because that request appears to be moot because both of her claims are blown out of the water. This is a giant L for Amber Hurd, a giant L in her quest to blame anybody but herself for her failures here. And because of that, ladies and gentlemen, I say cheers and definitely celebrate because once again, Amber is exposed for exactly who she is. And that is a person who is making material misrepresentations. Until next time, guys, peace.